The Supreme Court chamber fell silent as Elon Musk stepped forward to the petitioner's lectern, adjusting his navy blue suit with an uncharacteristic hint of nervousness. Choosing to bypass his legal team, the tech billionaire had decided to personally argue his company's landmark case against federal regulatory overreach. Across from him, Chief Justice John Roberts and Associate Justice Amy Coney Barrett exchanged subtle glances and unspoken skepticism that did not go unnoticed by the packed gallery. "Mr. Musk," Roberts began, his tone heavy with authority, "you've made the unusual decision to represent yourself before this court. While you're entitled to do so, I must remind you that this is not a tech conference or a social media platform." A ripple of laughter swept through the room. Barrett leaned forward, her voice edged with condescension, questioning whether he truly wanted to proceed without legal counsel, warning that the legal complexities at hand were extraordinary. Stood motionless, his expression unreadable. As the justices tried to undermine his credibility before he had uttered a single word, what followed would shock the courtroom, challenge long-standing legal assumptions, and reveal a side of Musk that even his fiercest critics had never imagined. This was no mere billionaire spectacle. It was about to become one of the most stunning displays of legal brilliance the Supreme Court had ever seen. Elon Musk, 53, the controversial tech entrepreneur behind groundbreaking ventures in electric vehicles, space travel, and now social media, was known more for his engineering genius and unpredictable public persona than for any legal expertise. Yet, he stunned the legal world by firing his high-powered attorneys and filing a petition to personally argue his company's case before the U.S. Supreme Court. The case, v. Federal Communications Commission, centered on complex questions regarding the federal government's authority to regulate digital speech platforms. Lower courts had consistently ruled against Musk's company, upholding recent FCC regulations on content moderation as constitutional exercises of federal power. The financial implications were massive, with billions in potential compliance costs and operational changes at stake, but for Musk, the personal stakes were just as high. Long criticized as a brilliant engineer, yet an impulsive, undisciplined thinker outside his technical field, Musk's decision to appear before the court represented either an act of unchecked arrogance or a bold attempt to prove his intellect extended far beyond rockets and algorithms. "Mr. Musk," Chief Justice Roberts began sharply, "this court's time is extremely valuable. I hope your decision to argue personally won't waste it." His tone made clear he saw Musk's presence as more of a spectacle than a serious legal contribution. Justice Barrett followed with a pointed observation. "The briefs submitted by your former counsel were quite thorough. I'm curious why you found them inadequate." It was a subtle trap with Musk would undermine his legal team or admit his appearance was unnecessary. The courtroom tensed as Musk adjusted the microphone, most expecting a humiliating performance from a billionaire and over his head. What they didn't know was that Musk had spent the past 6 months secretly preparing for this moment with a level of discipline and intensity that even his closest confidants hadn't seen before. "You, Justice Barrett," Musk replied, his voice calm and formal. "I have the utmost respect for my legal team. However, this case touches on the intersection of constitutional law, technological innovation, and the future of human communication, areas where I believe I can offer this court unique insights that even the most skilled attorney might struggle to convey without first-hand experience in building these systems." Several justices straightened in their seats, clearly caught off guard by the composure and clarity of his response. This was not the impulsive, tweet-first version of Elon Musk that many had anticipated. Instead, he remained composed and focused. "I believe the issues before this court today transcend conventional legal analysis," he continued. "They require a deep understanding of how content moderation algorithms function, the practical limitations of artificial intelligence in distinguishing protected from unprotected speech, and the global implications of American digital regulation." Roberts and Barrett exchanged another glance, this one more uncertain, as Musk began arranging his notes. The atmosphere in the courtroom shifted subtly. What had started as an effort to humble an overconfident billionaire was quickly evolving into something far more serious. "Mr. Musk," Chief Justice Roberts began, launching the first question. Your company's core argument seems to be that the FCC lacks statutory authority to implement these specific content moderation requirements. Yet the Communications Act explicitly grants the Commission broad authority to regulate interstate communications. Why should this court create a special carve-out for your platform? The question was carefully constructed to corner Musk, a tactic Roberts had used many times to expose unprepared advocates. But Musk nodded thoughtfully before answering. Chief Justice Roberts, he said, I believe there's a more fundamental issue at stake. The Communications Act was written in 1934, long before the internet, social media, or algorithmic amplification existed. While Congress has amended it over time, the specific provisions the FCC cites were never intended to regulate algorithm-driven content distribution or user-generated speech at this scale. Justice Barrett jumped in, her tone laced with skepticism. That's a convenient interpretation, Mr. Musk, but this court has consistently held that broadly written statutes can accommodate unforeseen technological developments. In Massachusetts v. EPA, for instance, we ruled that the Clean Air Act's definition of air pollutant was broad enough to include greenhouse gases, even though Congress clearly didn't foresee that application when drafting the law. The pointed reference to precedent was designed to test Musk's legal understanding. Many in the courtroom leaned forward, anticipating a stumble, but Musk didn't hesitate. Justice Barrett, he began calmly. I appreciate that reference, Musk replied, and it actually highlights a crucial distinction. In Massachusetts v. EPA, the court found that greenhouse gases fell squarely within the statute's existing definition of air pollutant. The application was novel, but the core regulatory principle aligned with congressional intent. Musk then turned slightly to address the full bench. By contrast, the FCC's current attempt to mandate specific content moderation algorithms is not simply a new application of an old a fundamental redefinition of the agency's role, shifting it from a technical infrastructure regulator to a speech arbiter. This isn't applying established law to modern technologies, rewriting the agency's core function without congressional authorization. Justice Sonia Sotomayor, typically skeptical of corporate arguments, leaned forward. Mr. Musk, your platform reaches hundreds of millions of Americans. When misinformation spreads, it can impact elections, public health, and national security. Given these stakes, why shouldn't the government have similar regulatory authority as it does over broadcast media? It was a challenging question, one that had left seasoned attorneys scrambling. Musk paused briefly, then responded with measured clarity. Justice Sotomayor, that analogy overlooks three key distinctions. First, broadcast spectrum is a limited public resource, which historically justified greater regulation. Digital speech platforms do not operate under the same physical constraints. Second, users actively choose to engage with digital platforms, unlike broadcast signals that enter homes unsolicited. And third, the content on my platform is overwhelmingly user-generated. We are far closer to a telephone network than a television station. Far from faltering, Musk was engaging the justices with a level of legal nuance that surprised many in the room. Justice Neil Gorsuch, known for his skepticism of administrative overreach, followed up. Even accepting your statutory argument, Mr. Musk, why shouldn't we defer to the FCC's technical expertise here under Chevron deference? It was a question that delved into one of the most complex areas of administrative law when courts should defer to agencies' interpretations of ambiguous statutes. Musk didn't miss a beat. Justice Gorsuch, I believe this case is a textbook example of a major question, precisely the kind this court, in West Virginia v. EPA, held falls outside Chevron's scope. When an agency asserts authority over an issue of vast economic and political significance, the court has made clear that Congress must speak clearly. The FCC's regulations would fundamentally reshape how nearly 2 billion people communicate worldwide. They would compel my company to re-engineer its core technology and, in effect, deputize a federal agency to regulate protected speech through technical mandates. If that doesn't qualify as a major question requiring express congressional authorization, I don't know what does. I struggle to imagine what would one of the justices began before trailing off as murmurs spread across the bench. They were now exchanging glances. This was not the performance they had expected. Justice Barrett, in particular, seemed increasingly engaged, her earlier skepticism gradually giving way to genuine intellectual curiosity. "Mr. Musk," she said, her tone now notably less dismissive. "Your brief cite Professor Lawrence Lessig's concept of code as law? The idea that software architecture can regulate behavior as powerfully as legal codes? Could you elaborate on how that theoretical framework applies to the specific regulations at issue here?" It was a sophisticated question that reached beyond black-letter law into abstract legal theory. It's clearly designed to probe the depth of Musk's preparation. What happened next stunned the courtroom. Musk stepped slightly away from the podium, his posture shifting from cautious to commanding. "Justice Barrett, I'm glad you brought up Professor Lessig's framework. It gets to the very core of why traditional regulatory models often fail in digital contexts," he began, speaking without notes. What followed was a remarkably lucid analysis that seamlessly wove together constitutional law, technical realities, and regulatory theory. When the FCC mandates the use of specific content moderation algorithms, it isn't merely regulating business practices, encoding law directly into the architecture of the internet. That distinction is critical because algorithmic regulation functions invisibly, continuously, and without the procedural safeguards that typically accompany traditional legal enforcement. It reshapes digital behavior not through open legal debate, but through opaque technical design. The courtroom remained completely still, no interruptions, no whispers, just a collective realization that this was no ordinary hearing. He illustrated his point with a technical explanation that, remarkably, remained accessible to even the non-expert listener. "Consider Section 4B of the regulation," Musk said. "It requires platforms to reduce the visibility of potentially misleading content. On the surface, that seems straightforward, but in practice, it compels us to design preemptive filtering systems that, by definition, restrict speech before any formal determination of its legality." He then pivoted seamlessly into constitutional analysis. This creates a classic prior restraint problems, something this court has consistently subjected to the highest level of scrutiny since Near v. Minnesota. Unlike traditional regulation, which punishes violations after they occur, algorithmic mandates impose censorship proactively based on probabilistic predictions. The courtroom had fallen completely silent. Even the most skeptical observers now saw that Musk wasn't merely reciting prepared talking points. He was synthesizing complex constitutional doctrine with technical realities in a way that even veteran Supreme Court litigators rarely managed. Chief Justice Roberts, who had initially regarded Musk with thinly veiled condescension, now leaned forward, visibly intrigued. "Mr. Musk," he said, "that's a persuasive theoretical framework. But let's talk about practical application. How would you suggest addressing genuine harms like coordinated disinformation campaigns by foreign governments without relying on the kind of algorithmic requirements you're challenging?" It was the kind of high-stakes question that often caused advocates to fall back on vague principles or grudgingly concede the necessity of regulation. But Musk responded with something no one had anticipated: a detailed, constitutionally grounded regulatory alternative. "Chief Justice, I believe there are three approaches that meet both the government's legitimate interests and constitutional requirements," Musk replied. He then outlined a sophisticated framework centered on transparent disclosure mandates, user-controlled content moderation tools, and narrowly tailored enforcement against clearly defined illegal content categories. The technical precision was impressive on its own. But what truly stunned the courtroom was Musk's ability to ground each proposal in established Supreme Court precedent and statutory authority, citing cases and legislative provisions with the fluency of a seasoned legal scholar. Justice Barrett, whose skepticism had been most pronounced at the outset, leaned in with a follow-up that marked a dramatic shift in tone. "Your framework is intriguing, Mr. Musk," she said. "It seems to draw from Justice Kennedy's concurrence in Packingham, North Carolina, recognizing the internet as the modern public square, while still addressing the government's Interest in preventing concrete harms. Have you considered how your proposal would operate within the boundaries of the current statutory landscape? It was a question that treated Elon Musk not as an overconfident amateur, but as a serious constitutional thinker. His response reflected not only legal acumen, but strategic sophistication. Justice Barrett, Musk began, I believe existing authority under Section 5 of the Federal Trade Commission Act already provides a statutory foundation for the transparency and disclosure elements I've proposed. As for content-specific regulation, narrowly tailored amendments to Section 230 would be more appropriate than FCC rulemaking. He continued with remarkable clarity. This approach respects the separation of powers by preserving Congress, not administrative agencies, as the primary architect of Internet governance policy, a principle this court underscored in FDA v. Brown and Williamson Tobacco. What had started as an effort by Roberts and Barrett to challenge a presumptuous billionaire had evolved into one of the most sophisticated constitutional dialogues the court had seen in recent memory. Musk was no longer simply holding his ground. He was advancing novel, well-structured legal frameworks that visibly engaged and intrigued the justices. Meanwhile, the Solicitor General representing the FCC looked increasingly uneasy as he watched the justices respond with unexpected seriousness to Musk's arguments. What should have been a routine defense of agency authority was rapidly becoming an uphill battle against a surprisingly formidable opponent. As Musk began to wrap up, Chief Justice Roberts, now fully immersed in the substance of the case, posed one final question. Mr. Musk, given your technical expertise, can you explain why the FCC's approach to algorithmic regulation is not just legally problematic, but technically unsound? It was a perfect opportunity for Musk to fuse the legal and technological dimensions of his case, and he seized it. Over the next 4 minutes, he delivered a masterclass on how content moderation algorithms function in practice, the inherent limitations of AI in distinguishing protected from unprotected speech, and the inevitability that the FCC's mandates would result in both overblocking of legitimate speech and underblocking of harmful content. His explanation was so clear and precise that even justices with limited technical background could grasp the practical flaws in the regulation. Musk concluded by tying the technological failures back to constitutional principles in essence. He said the FCC is mandating a technical solution that, by design, cannot achieve its stated goals without causing significant collateral damage to protected speech. That is the constitutional failure at the heart of this case. The outcome was the very scenario this court's First Amendment jurisprudence has consistently sought to avoid. As Musk returned to his seat, the courtroom remained silent observers, still processing what they had just witnessed. What was expected to be the public unraveling of an overconfident billionaire had instead become a stunning display of legal and technical mastery that visibly impressed even the most skeptical justices. Barrett and Roberts exchanged one final glance, this one reflecting a shared realization they had seriously underestimated the man before them. Within hours of the oral arguments, legal blogs and major news outlets exploded with headlines such as Musk shocks Supreme Court with legal brilliance and tech billionaire outmaneuvers nation's highest court. Clips of the most compelling exchanges spread rapidly across social media, sparking widespread debate. Legal experts expressed open astonishment. I've observed Supreme Court arguments for over 30 years, said Harvard law professor Lawrence Tribe on a cable news panel. I can say without hesitation that Musk's presentation ranks among the most impressive I've ever seen from a known attorney. The integration of technical knowledge, constitutional theory, and case law was extraordinary. Legal Twitter erupted with commentary. The moment Musk cited Justice Kennedy's Packingham concurrence and linked it to Lessig's code as law. Framework was absolutely extraordinary, wrote a prominent appellate attorney. He wasn't just reciting talking points, he was making law. He was synthesizing complex legal theories in real time, a level of intellectual agility rarely seen, even in that courtroom. According to court insiders, the justices' private conference following the arguments was unusually animated. While deliberations remained confidential, sources close to several justices revealed that Musk's arguments had significantly shaped the discussion, with multiple justices expressing surprise at the depth and coherence of his legal analysis. 3 weeks later, the influence of Musk's performance became unmistakable when the court took the rare step of requesting supplemental briefing on several of the alternative regulatory frameworks. He had proposed an extraordinary move that signaled the justices were seriously considering his ideas rather than limiting their decision to the arguments originally briefed. Legal scholars across the country began analyzing what quickly became known as the Musk approach to tech regulation, exploring how his proposed framework might redefine the balance of power between government agencies and digital platforms. Law professors added the oral argument recording to their constitutional law syllabi as a model of effective interdisciplinary advocacy. For Justices Barrett and Roberts, the experience prompted subtle but lasting recalibrations. In subsequent, tech-related cases, both adopted a noticeably more respectful tone when questioning advocates on technical matters. Barrett later told students during a law school visit that the argument had served as a powerful reminder that legal insight can come from unexpected places, and that assumptions about who possesses it are often misleading. Months later, speaking to the American Law Institute, Roberts made what many interpreted as a reference to Musk's appearance. As technology reshapes society, he said, the most valuable legal insights may increasingly come from those who understand that technology from within, not just from those trained in conventional legal doctrine. For Musk, the Supreme Court argument marked a turning point in his public image. Though still a lightning rod for controversy in business and media, he had indisputably established himself as more than just a brilliant engineer or provocative billionaire. Constitutional scholars and legal commentators who had once dismissed him began to engage seriously with his ideas on digital rights and regulatory reform. And when the court finally issued its ruling 6 months later, a 7-2 decision that largely adopted the framework, Musk had laid out his place in the legal history of the digital age, was firmly secured. Musk's position ultimately prevailed, with Justice Barrett authoring the majority opinion that repeatedly cited his technical explanations and adopted much of his framework for distinguishing between constitutionally permissible transparency regulations and unconstitutional algorithmic mandates. In a concluding paragraph widely seen as a direct acknowledgement of Musk's impact, Barrett wrote that as technological innovation reshapes how Americans exercise their First Amendment rights, courts must remain open to insights from those who create and understand the systems being regulated, emphasizing that the intersection of code and law requires both legal humility and technical precision. The case quickly entered constitutional law textbooks not only for its substantive rulings, but as a pivotal moment in how courts approach digital speech regulation. What began as an effort to humble a tech billionaire evolved into the recognition of a novel legal philosophy later dubbed Musk jurisprudence, which prioritizes transparency, user choice, and technological reality over top-down algorithmic mandates. For a legal community that had initially dismissed Musk as an outsider, the lesson was clear. In an era where technology and law are inseparable, deep technical understanding can be just as essential as traditional legal training. Musk's performance didn't just change the course of one case, it helped reshape the constitutional landscape for digital speech for generations to come.